taxing Kenyans to finance the affordable housing project as enshrined in the Finance Act of 2023 after a three-judge bench led by Justice David Majanja granted the respondents a stay order pending an appeal to the Court of Appeal before January 10, 2024. Judges David Majanja, Christine Meoli and Lawrence Mugambi had earlier declared the housing levy that was introduced by President William Ruto as unconstitutional. Mike Kagwongo opens our broadcast tonight with that report.
In a landmark ruling Tuesday, the High Court has thrown a spanner in the works for President William Ruto's affordable housing plan, with the three-judge bench now saying that a 1.5% levy imposed as part of the finance law approved in June to finance affordable housing was unconstitutional.
I only conclude that the respondents took the easy path of least resistance, as taxing employees informal employment is easier. It is also the respondent's constitutional responsibility to create a broad, efficient, fair tax system that complies with Article 201(b)(1) of the Constitution.
Revenue-raising measures are provided for in the Finance Act, which is a money bill recognized by Article 114 of the Constitution.
However, the ruling was stayed until January 10 to give the government time to file an appeal.
An order of stay is hereby issued, staying the effect of this judgment issued today, 28 November 2023, pending the filing of a formal application for conservatory stay and conservatory orders in the Court of Appeal. And these orders of stay shall remain in force until 10th of January 2024. Those are our orders.
The stay orders comes in response to a request for 45 days to abide by the court's decision made by the respondents in the case, represented by Advocate George Murugara.
We will also be filing the substantive appeal in the Court of Appeal. And I hope and pray that once we go to the Court of Appeal, the orders we have just gotten here will be extended until the appeal is heard and determined.
The court ruled that the Kenya Revenue Authority, KRA, was not authorized by law to collect the levy, as the levy was unconstitutional and ambiguous. Additionally, the court determined that the levy was discriminatory because it only applied to Kenyans who are employed, and the government failed to provide the explanation for its exclusion of other income-earning groups.
We have, however, found the reasoning by the court to grant a stay of its decision until 10th of January 2024 a little bit strange. It is strange in the sense that it appears intended to allow the government to collect the housing levy. It appears intended to allow the government to have time to finalize the processes that are ongoing in Parliament. Judges David Majanja, Lawrence Mugambi and Christine Meoli, who made up the three-judge bench, ruled that sections 84, 72 and 78 of the Finance Act were void. As a result, Kenyans will keep contributing 1.5% of their income to the fund, with an equal contribution from their employers, which some says will continue inconveniencing their income despite the process being unconstitutional.
Sasa nazidi tu kutoa weko ushuru hapa. Hiyo ushuru haitafanya kazi yoyote.
Leo hii nashukuru Mahakama Kuu, the next court in line, our appeal court judges wamekubaliana na msimamo wa azimio la Umoja wa Kenya, wakatupilia mbali ushuru wa inaitwa housing tax.
Mike Kagwongo, TV 47, Nairobi.